Hello, my name is Natalie Skillington, and this is my presentation for the ethical dilemma based on the ethical vignette assignment that we had previously. So, so the video that I chose to write my ethical vignette assignment on and to do this presentation with was the helpful receptionist. So in this video, a man approaches the receptionist at a place, I believe it was called the Metropolitan Counseling Center. It is fictitious, obviously, for the purpose of the video. But he doesn't explicitly ask for any information. He says that he is the husband of a current client at this counseling center and that he is unable to reach her at the moment, that he needs to pass on a message because he has to go. So he doesn't again explicitly ask for any information, but the counselor confirms that his wife is a client there just by like nodding and saying okay. And instead of just stopping the man and saying, "I'm sorry, sir, I cannot confirm or deny whether or not any person is a client here," she confirms that she inadvertently confirms that his wife is receiving care there. And then when the man leaves and his wife comes out, uh, the receptionist shares with the client that the man was there, and that he had a message to pass on to her. And you can immediately see the distress on this client's face because this was not information previously given to the man by the clients, and they're having a battle for custody and a divorce. And she believed that this man was going to use the information of her receiving counseling as a way to get like up on her like in the court and use it against her basically. So even though the receptionist did not actually share any new information, by confirming what that man had, she violated the client's confidentiality and privacy. And then she violated HIPAA, the ACA 2014 Code of Ethics, the client's autonomy, fidelity, and beneficence. And then even though it was deceptive and she didn't give out any specific information, she did confirm it and it did do harm to the client. So these are the codes that are very specific to what the receptionist violated. So the 2014 ACA Code of Ethics, she violated code B1B, B1C, and B2E. So code B1B states that a counselor essentially must respect the privacy of all clients, even prospective ones, so even ones that might not officially be a client, and only asking for more information when needed, which is basically like a need-to-know basis. Section B1C states that counselors should respect the confidentiality of all clients, even prospective ones. And only share information when they have a solid legal backing and a solid legal reason, and when it's very appropriate. So an example of this could be written out like writing a referral for a client to go see a new counselor or something like that, and giving them very minimal information with the client's permission. And then finally, section B2E states that when disclosing confidential information about a client or prospective client, again, even in the appropriate setting and circumstances, the counselor must only share the minimum amount of information possible. So again, like giving very minimal information when making a referral or maybe consulting with a colleague or something like that. So then the next is the 2023 Florida statute, which is section 90.5032. And that states that mental health and medical organizations both are responsible for respecting a client's rights to disclose or not disclose information that they would like to. So this includes whether or not client receives any treatment at a facility. And two major factors that proved this violation. The first one is that Mr. Jones was previously unauthorized. And the second is that Mrs. Jones in this scenario was displeased with the disclosure of the confidential information. And then finally, the last violation, the HIPAA violation from 1996. It is section 164.510, which states that organizations possessing any protected health information, or PHI as it is often shortened, must protect it and can only release it to family members if these family members have been given specific permission from the client in advance. So because this man was still technically a family member, as he was still technically legally her husband, he was not given permission to receive any of this information. So the nature and the dimensions of this is that it violated her autonomy, fidelity, and beneficence. All three, personally, I believe fidelity is one of the biggest ones here. So beneficence, because quite literally this action caused harm, and beneficence states that the counselors should not or should do everything that they can to promote the well-being and not diminish the well-being of a client. So the fidelity was violated because the counselor entered an agreement with the client when they reviewed the information, consent documents, and everything, and the client agreed to do services there. So this agreement includes the ACA Code of Ethics, the HIPAA rules, not sharing PHI, and that no unauthorized third parties should get any information. And then finally, the client's autonomy was violated because they didn't consult her and she had no choice in the information that was shared. Additionally, she expected them not to share this information based on their previously established agreement of privacy and confidentiality, which they broke without a valid reason. A valid reason, according to Urso from 2021, would be, threat of suicide or harm to another individual. And these summarized definitions of autonomy, fidelity, and beneficence are from Forrester, Mill, and Davis, and then Pearson, the 2020 textbook, or the video as well, and then Mansoray Mani. So fidelity meaning that a client's, they're in a trusting relationship and that won't be violated. Autonomy meaning that a client has choice over their life and their actions, and beneficence meaning that the well-being will be protected and promoted. So the nature of this, in that situation, I think it would have been best to consult the supervisor, coworker, and attorneys to see what needed to happen prior, and if she can share that information, or even look at records to see what information can be shared with whom. So potential courses of action. So I have 3 here, regardless of what course I choose. The first 4 steps for me would be the same. So I would immediately notify a supervisor of what has happened. I'd write a detailed incident report of what happened, this being if I was the receptionist. And then I would report the violation to the Code of Ethics, and then I would inform the organization's attorney as well of the incident while providing them the incident report and things like that. So then going a little into the weeds more, the first course of action would be to terminate the receptionist. This could be very beneficial because it would show that you don't put up with violations. And also it would show the client that you take this kind of thing very, very seriously. The second course of action is a little bit more in depth. It takes a little longer. It would be to suspend the receptionist and conduct an investigation. So that would be talking to the man, Mr. Jones, if you could, talking to the woman, Mrs. Jones, the client, talking to the receptionist, getting the video logs, stuff like that. And then in this situation, the receptionist still would most likely be terminated because she did in fact violate the Code of Ethics, HIPAA, and Florida state statutes. And then the final potential Course of action would be to find the receptionist and put a temporary suspension on her. All of these I think are quite serious and none of them are potentially wrong. But I do think that finding the receptionist and just putting her on a temporary suspension is one of the more lax options. So some potential consequences of each action are as follows. So of course, number one is that uh, it would show that the client that I take violations quite seriously, and the receptionist actions were not up to standard. However, without maybe an investigation done or a deeper look into what happened, you could be subject to potential wrongful termination, although I don't think that would be successful. Course number two is that it would again show that I take that the receptionist is not up to the company standards and that we don't accept violations and things like that. And then I do also think it would protect the company. It would make sure that due diligence is done and that investigations are being conducted. And that you really are diving deep into what happened and not just taking anyone's word for it. And then number three is that it may potentially, a consequence could be that it could invalidate what the client, like the wrongdoing of the client and the harm done to them. And the client may also no longer trust the counselor or the organization and probably would not like to come back and see the receptionist again after that violation had happened. So I have chosen course action number two. And the reason I did this is because it shows care and concern for both the client and the employee. I believe that by doing an investigation, you're not just taking anyone's word for it, and that you're also quite literally like diving deep into it and trying to make sure that um, the best course of action is chosen, quite literally. His does the due diligence to ensure that what the course of events were and the extent of the validation or violation, I'm sorry, and it also validates the client's feelings of distress and betrayal by the organization and the receptionist. So with this, I don't potentially see any ethical concerns. This could just be because uh, there's stuff that I just don't know, but it would stand against the test of justice, I think, because it doesn't take anyone's word and it really digs into the issue. And I do think that the general public will never fully agree with a resolution of an action like this, but I think that the due diligence is done and that reasonable efforts were completed to enforce the code of ethics here. And so maybe not like, because you can't please everyone, but I do think that people reviewing this would be happy with that choice. And then additionally, conducting an investigation before making a decision that affects the well-being of both the client and the employee, I think would be a good rule of thumb. So some final steps would most likely be to terminate the receptionist and then completing a full report of the incident and providing it to the client as you could see with, they could use it for their legal and custody battle and things like that. And just to have on their private records. And then I would consult the client on her feelings, opinions, views, and everything going on, see how the client is doing, really try to check in with them. Do everything that you can to preserve and rebuild that relationship because it's definitely been damaged. But it may be not able to be preserved because of the violation that happened and how she was hurt from that. And then finally, here are my references. Thank you.